Kalispera sirs. My name is Loizou and welcome to this week's Family Law Show, brought to you by the International Family Law Group. I am your host, and in this week's programme we're going to look at how you can achieve a divorce in an amicable fashion. I'm going to first of all describe a little bit about myself, the firm that sponsors this programme, and then we're going to move on to today's show. So a little bit about me. Some of you may be familiar with me already. I am a family law solicitor and a partner at the International Family Law Group. I specialise in all cases concerning family law. I deal with cases that concern financial matters as well as those cases that concern children. I've been practising family law for a number of years and I specialise in cases that have an international element. I have also had my own radio show on London Greek Radio for the last 2.5 years, where I have been given our viewers and listeners advice about family law. I also write regularly for the Barigiagi newspaper and lecture to other family law solicitors up and down the country. In terms of the firm I work for the International Family Law Group. We're a niche family law firm based in Covent Garden and in central London. We provide family law services to both national and international clients and specialise in cases that have an international element. So moving on to today's programme. As I say, we're going to be looking at how you can keep a divorce amicable if you happen to be in the circumstances of having to go through that. So moving on to today's show then. As a divorce lawyer, I often see how acrimonious divorces can become, with cases ending up in court and sometimes taking years to conclude. Emotions will often run high during this stressful time for all involved. Sadly, children often become the pawns in the complex world of chess, otherwise known as divorce. It doesn't need to be this way, and I always encourage my clients to try and resolve matters in a conciliatory and non-confrontational fashion, not just for their own sake, but also importantly for their children. An amicable settlement, of course, can't always be reached, and at times the court's assistance is required. But in the majority of cases, I'm a strong believer that it doesn't have to be messy. So in this week's programme, we're going to give guidance on how you can achieve that amicable divorce. Each individual case will be different and have different requirements, and you should speak to a family law solicitor about your own circumstances. I will be happy to assist, and I will be giving our contact details at the end of this programme. So what are the 5 top tips? First of all, take independent legal advice early on if your relationship has broken down. This isn't so that a family law solicitor is going to become instructed in your case so that they become formally involved, but actually more to benefit you to find out general information about the divorce process and how finances are dealt with on divorce. If you then choose to discuss matters with your spouse amicably, that's good news, as opposed to instructing a lawyer. But at least by seeing a lawyer, you will know what that process entails. Tip number 2, you should explore with your solicitor right at that first meeting whether mediation is an option. Now I'm going to talk a little bit more about mediation shortly and give a bit more detail. But mediation is successful in a large number of cases. And the process entails a couple meeting with a mediator, who's usually a trained family law solicitor, and they have a series of meetings to try and discuss and agree issues amicably. This can be both in relation to finances and also children matters. A mediator isn't going to advise either party as to their rights in law. Your solicitor will need to do that. But what mediation does do is it provides an informal setting enabling legal discussions to take place in a relaxed and an unpressurised environment. One thing I would just say to our viewers is that mediation may not always be initially appropriate in all cases, particularly where the parties have international connections, specifically in Europe. Again, this is something that you should discuss with your solicitor at that first meeting. So number 3, you should try and view your divorce, in my opinion, as a means to an end, instead of it being a mudslinging exercise. This, of course, is easier said than done when emotions are already running high. But from a legal perspective, it doesn't matter on what grounds the divorce is based. An English court won't make any moral judgment as to the reasons for your divorce. Further, and importantly, in the large majority of cases, the financial outcome will be unaffected by the reasons set out in your divorce paperwork. So, for example, just because a spouse has committed adultery, it doesn't mean that you're going to get more money in the overall financial settlement. If you have international connections, particularly within Europe, there will often be significant financial advantages in issuing divorce proceedings first and in a country that will give you the better financial outcome. So in this scenario, and prior to discussing your divorce with your spouse, make sure you take independent legal advice quickly from a family law solicitor who has experience in dealing with international cases. I will be able to assist in this regard. So tip number 4. Try not to expose the children to adult issues. Don't discuss these matters with them or use them as a negotiating tool for your financial gain. This kind of behaviour is really condemned by the courts, and it only serves to heighten tension. Remember that in the future you'll need to retain and maintain a relationship with your spouse as a parent. You'll need to work together to make decisions for your child or children as they grow up. So try and agree a care pattern that works not just for you as adults, but importantly for the children. Their welfare will always be the court's paramount consideration. You should also be prepared to compromise and show flexibility where possible. Statistics show that the care arrangements reached by parents by consent, as opposed to them being imposed by a court, work more successfully. And finally, the tip. Always remember that the end is in sight. Once the divorce is concluded, you'll be able to start afresh. It can appear as though it's a never-ending process, and the more you can agree by consent with your spouse, preferably with legal assistance and advice, the better for all concerned. So what I want to spend the next 10 minutes on is just looking at some of the alternatives that are available to couples instead of going to court. We've looked at some ways of dealing with things amicably, but I just want to describe some of the methods that you can use. So let's look at some of those options that are available to couples who are divorcing and they wish to avoid having to go to court to resolve their financial or children matters. These methods that I'm going to be talking about are collectively known as alternative dispute resolution. So these are alternatives to court proceedings. As I say, they are collectively known as alternative dispute resolutions. Any of the following that I'm going to speak about can be used to enable a couple to reach an out-of-court settlement. So let's look at those methods. Number 1, mediation. We've touched on it briefly already. It's a process in which an impartial third person assists those involved in a family breakdown so that they can better communicate with each other and reach their own agreed and informed decisions about some or all of the issues arising from their separation, divorce, finances or property. Usually, a number of mediation sessions take place prior to a settlement being reached. It's important to be aware that mediation is only likely to be effective when the couple involved feels that though they are committed to the process. It won't work if you do not feel committed or they feel as though they have been forced to enter into the process as opposed to going into it by choice. Couples should be aware that changes were made last year, which now make it compulsory for them to attend what's known as a family mediation and assessment meeting prior to issuing any financial or children application to the court. There are exceptions to this rule, however, the general ethos is that couples should work together to resolve their differences as opposed to going to court. So the second method in terms of resolving a dispute and the alternative method to going to court is something called collaborative law. Now, collaborative law is a process by which family lawyers and their clients agree in writing to reach a settlement in relation to issues involved, and they also agree not to go to court. They work together to resolve issues concerning children and the finances arising out of their separation. Settlements are usually obtained by a series of four-way meetings involving the couple and their respective lawyers. Collaborative law has a number of benefits. It can help the weaker financial party feel less vulnerable. The clients remain in the process, but they have their lawyers there present to provide them with legal advice and guidance. The costs of the collaborative process can be high, so it's important to bear that in mind. Also, if no settlement can be reached, then the collaborative lawyers must withdraw from acting for their clients, and new lawyers must be instructed to take the matter forward to court by way of court proceedings. So the third option to look at, something that's relatively new in the family law world, it's something called arbitration. As I say, this is a new model in family law. Arbitration occurs when a lawyer qualified as an arbitrator acts in effect as a private judge. The couple therefore engage in a mini court trial where the judge will make a decision which will be binding. Arbitration doesn't take place in a courtroom. Often this happens in meeting rooms. There is no necessity for a court application to be made in order for arbitration to take place. One of the advantages of arbitration is that the arbitrator can be chosen for the required experience or specialisation of the area of dispute. Arbitration is quicker and more flexible than the court process. Again, it can be expensive, so it's important to discuss the estimated costs with your lawyer before embarking on this process. Another method, early neutral evaluation. This basically is an opinion given at an early stage in a dispute by an experienced lawyer as to what may be the outcome if the case were to end up in court. It can save costs and it can become a good indication of a fair settlement. Another method, lawyer negotiations. This remains probably the most frequent form of out-of-court settlement. Each party has their own legal advisor who advises them and negotiates on their behalf throughout the case via correspondence. Once a settlement is reached, the lawyers are then responsible for drawing up a financial settlement order which records the agreement that both parties have reached. If you are going through a difficult divorce, then you should always consider and discuss these methods with your lawyer before issuing a court application. It doesn't always have to end up in court. Statistics show that settlements agreed by consent, whether relating to the finances or children, have a better chance of being adhered to than those that are imposed by a judge. I'm a member of an organisation called Resolution. Now, Resolution is a national family law group that promotes the settlement of family law matters in a conciliatory and amicable way. I strongly endorse this approach in my day-to-day work. Inevitably, there are going to be cases where the court can't be avoided and the scope for court applications can't be limited. However, these methods of alternative dispute resolution that we've described are good news for families because it means that you can do things amicably. So that concludes just a few points in relation to tonight's show. There are quite specific topics that we've discussed, and if you would like any further information to any of these issues, please do not hesitate to contact me at my firm. As I say, I am a family law solicitor and I work for the International Family Law Group. We're based in Covent Garden, and the telephone number is 0203 178 5668. That's 0203 178 5668. Alternatively, please feel free to take a look at our website www.iflg.uk.com. So that concludes this evening's programme. Thank you very much for tuning in, and we look forward to you watching again next week. Ευχαριστώ και καλή νύχτα σας.